Okay, whenever you're ready, Jean.
I'm ready. Good afternoon, everybody. I'm Gene Coleman, family law lawyer in Toronto, and along with Brian Ludmer, my co-speaker today, we are co-sponsors of this very important conference. I will be speaking on the newly expanded definitions of family violence in the Divorce Act of Canada, and Brian Ludmer will be speaking on how family law deals with coercive control, gatekeeping, enmeshment, false allegations, and alienation. Next slide. The drum roll is only on the first slide, so don't be worried. I was just playing around. Here we have some of the topics we're going to be discussing. Next slide. And next. And that's where we're going. So next. Family violence. What is it? One would not be blamed if he assumed that we are dealing here simply with assaults, threats to hurt someone, and similar nasty behaviors. But the Divorce Act now goes a lot further. Family violence is now a drastically expanded concept that encompasses behaviors that frankly might surprise you. Next. Next. Actually, that's the slide after. I'll just go ahead and we'll get up to that slide. No, 6, slide number 6. Sorry, slide number 6. One back. Thank you. I wonder if you have the old version of my presentation because the slide numbers I think have changed. But anyways, let me go ahead. Men in particular can be victims of family violence without even realizing that the bad behaviors to which they are subject are caught within the definitional framework. No, we're on the right slide. And on the flip side of that proposition, men might engage in behaviors that they might think are not so bad. But stop right there. The law now defines family violence in exceptionally wide terms. It's best to know in advance what the law says. So let's spend some time this afternoon delving into some of these introductory concepts of family violence in Canada. The Divorce Act was recently amended. We're on the right slide. That's fine. Surprisingly, the term family violence was not actually defined in the Divorce Act until Bill C-78 came into force on March 1st, 2021. With this amendment, Canada's Parliament has implemented significant, and I would say startling, changes to the law of parenting, formerly known as custody and access. One of these changes, quoting Bill C-78, was introduce measures to assist the courts in addressing family violence. Next. Family violence means, under Section 2 of the Act, means any contact, whether or not the conduct constitutes a criminal offense by a family member to another, that is violent, threatening, constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person, and includes, in the case of a child, direct or indirect exposure to such conduct, and includes, next slide, physical abuse, including forced confinement, sexual abuse, threats to kill or cause bodily harm, next, harassment, including stalking, failing to provide the necessaries of life, psychological abuse, next, financial abuse, threats to kill or harm an animal or damage property, the killing or harming of any animal. So you threat to kill the animal, you threat to harm the animal. Violence to pets is a no-no. This is not an exhaustive list. Next. Some takeaways from this definition are, in my view, the following. 1, the violence does not have to equal a criminal offense. They're not the same. Secondly, any behavior that a family member might perceive to be violent or threatening could, in my view, constitute family violence. Thirdly, coercive and controlling behavior of any kind will constitute family violence. Now, this morning in the Rosedale room, we heard Mr. Hamill. He addressed us. He said, and I quote, "Coercive control has been bastardized," end quote. And he also said that this concept of coercive and controlling behavior has been, quote, "shamelessly misused," end quote. And those words of Mr. Hamill rang loud and clear for me, as I hope they do for you. Next, sexual abuse by one partner against the other will constitute family violence. And if you stalk your spouse, either before or after separation, it's family violence. And I say, my view, that stalking can include online stalking. Next. Think twice before canceling credit cards or otherwise limiting spending. It could very well be family violence. You smash a door, you break a glass, even where the other spouse is nowhere near and the child's nowhere near, it's family violence. Say you threaten to do any of these bad behaviors, but you don't actually do them. It's family violence. Bad behavior, in the widest sense of the term, can now constitute family violence. Next. Let's have a little note on jurisdiction here. The Divorce Act of Canada addresses married people who are divorcing. Provincial legislation, such as Ontario's Children's Law Reform Act, addressed cases where the children's parents were never married to each other. To ensure that the same changes in the Divorce Act, a federal statute, apply to all children, the Ontario government enacted Bill 207 to amend the Children's Law Reform Act in similar terms as the federal amendments. We will generally only refer to the Divorce Act provisions, but keep in mind that unmarried parents in Ontario and in other jurisdictions in Canada, as noted on the screen, with similar amendments will be governed by this new system. And I gather that other jurisdictions such as California have similar provisions as ours. Next. So why do family violence amendments matter? Well, first of all, there's a matter of agenda. The agenda seems to have been to reduce the parenting role of violent parents, at least violent as defined by the definition. Next. Family violence permeates the amended Divorce Act. I say that you simply cannot ignore, marginalize, or otherwise disregard allegations of bad behavior, as was the case previously in some circumstances. Next. Best interests is king. In addition to including and defining family violence, the bill, the amendments, further elucidated the concept of BIOC, or best interests of the child. Now, best interests of the child is the only test. Section 16, sub 1 of the Act says that, quote, the court shall take into consideration only the best interests of the child of the marriage in making a parenting order or a contact order, end quote. This obligation on the court is not new, but it is still noteworthy that BIOC trumps all else. Next. The Divorce Act, section 16, sub 3, tells us to consider, quote, all factors related to the circumstances of the child, including, and then we have a whole shopping list of various factors, but for the purposes of our presentation today, we're going to focus on sub 3J and sub 3K. So first of all, J, any family violence and its impact on, among other things, ability and willingness of any person who engages in it to care for and meet the child's needs. And secondly, the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate on issues affecting the child. So you see two points here. The family violence perpetrator, his ability and willingness to meet the child's needs. And secondly, is it appropriate to require the victim of family violence to cooperate? And K, next slide. Any civil or criminal proceeding, order, condition, or other measure, that is relevant to the safety, security, and well-being of the child. Next, so what are the takeaways? What we've looked at now. In my view, they are as follows next. Section 16 sub 3 gives us a non-exhaustive list of factors that the court must consider to determine best interests of the child. There is room here to expand on any kind of bad behavior, in my view. The Divorce Act brings back bad behavior into the statutory criteria. What is to prevent further evidence of bad behavior, especially when it might be analogous, close to, or meet the wide definition of family violence? Next. Family violence does not have to be committed directly in front of the child. Rather, if the behavior is deemed to constitute family violence, then the court is empowered to consider what the effect of that family violence could be on the child. Nowhere does it say that the effect must be direct. Let us say that you commit family violence against your wife. Know that this can impact the child too. Next. Family violence may make it impossible or just difficult for your spouse to cooperate with you on parenting issues. If the other parent is living in fear of you because of your family violence, reminder, widely defined, then perhaps equal shared parenting, formerly called joint custody, will just not be an option, but I'll have further words to say towards the end of my talk on that. And next slide. There seems to be an implication that the family violence perpetrator is not at all qualified to really care for and meet the child's needs. Next. Subsection 16.3J, we look at, that's the one about the ability and willingness of the family violence perpetrator to care for the child, about the ability of the family violence victim to have to cooperate. You recall that, cooperate with the perpetrator. But has further factors set out to assist in interpretation. And that's where we go to 16 sub 4 that we look at now. And I see we are there already. Good. In considering the impact of any family violence under J, the court shall take into account the following: nature, serious, and frequency of the FV, pattern of coercive controlling behavior, whether it's directed towards a child or not, physical, emotional, psychological risk of harm. Next. So just a risk of harm. Compromise to the safety of the child or other family member. Whether the family violence causes the child or other family member to fear for their own safety or for that of another person. Any other family member, note that. G, any steps taken by the person engaged in the family violence to prevent further family violence from occurring and improve their ability to care for and meet the needs of the child. I'm going to have some words on that in a moment. And watch this one, H, any other relevant factor. It's really wide, folks. Next slide. So let's again look at the takeaways from what we just looked at now. Next. J of 16.3 sets the stage for a finding that any family violence of any kind has the potential to ensnare you in the court finding that contact with your child is not in his or her best interest, simply because the family violence victim is made to feel insecure, unsafe, etc. 16 sub 4 gives us the roadmap to interpret sub J. Was there a pattern of coercive and controlling behavior? Watch out, folks, with that one. Thirdly, did your behavior constitute a risk of harm to the child? Fourthly, did your behavior even cause even any, as I said, I would emphasize this, any other family member to fear for their own safety? That casts a very wide net indeed. What if you make the second cousin once removed feel unsafe? Hopefully we won't go there, but I think grandparents would be included. I think they would. Watch out for sub H above, any other relevant factor that can capture anything at all. And now let us turn to what I believe to be the most important and earth-shattering factor that should guide all lawyers and litigants in our family law system where family violence is alleged, and it seems as if it will likely be proven. Sub G states, quote, any steps taken by the person engaging in the family violence to prevent further family violence from occurring and improve their ability to care for and meet the needs of the child. That is, in my view, a rather significant safety valve. If you are going to be caught by the family violence spider's web, if you have indeed behaved badly within the meaning of the Divorce Act, then you must take, in my view, substantial, persuasive, credible, and all-encompassing steps to address the issues of your alleged family violence. Your residential time with your child is at stake. Your decision-making responsibilities with respect to your child is at stake. Next slide. In my view, if you can clearly demonstrate that you have changed your ways, that you have gathered education and insight, that you no longer pose any risk of family violence to anyone, not just your spouse, to anyone, then perhaps you will be able to salvage a meaningful relationship with your child. On the flip side, if you are the victim of family violence and the offending spouse has not taken any steps to ameliorate her behaviors, then point to this subsection and argue that the court must ascribe some meaning to it, and in the absence of evidence under sub G, the child is still at risk. There are less well-known sections of the amended Divorce Act that mandate an examination of family violence, even when there has been no criminal conviction. Let's look at some of these revolutionary statutory reforms. Next. The Divorce Act now recognizes that there could be other orders or similar directives that could be relevant to the divorce proceedings, specifically to parenting. 7.8 of the Act addresses this reality. It charges the court with the duty to, when appropriate, determine if there are any civil protection orders, child protection orders, or any order, watch this one, undertaking or recognizance within the criminal law system. Undertaking and not yet, go back. Undertaking and recognizances are not findings of guilt. There are a myriad of other measures that could be caught within 7.8. Take note again and again, I know I'm repeating it, but take note that an actual criminal conviction or formal finding under the child protection legislation is not required. Those of us who were privileged to hear Professor Kruk before lunch, he advocates for a child protection legislation standard. There has to be a finding. Professor Kruk and I have for years been discussing that issue, but the law is not going the way Professor Kruk would like it to go. If there is any sort of order or direction, any sort of order, any sort of direction, anything, the court can consider it. Is a criminal charge without proof of guilt good enough? I hate to say it, folks, but likely yes. Now we go next slide. What about relocating your residence, relocating, just moving residences, but actually relocating? Could be across town, could be to another city, another country. Next slide. The Divorce Act requires a parent who intends to move or relocate and who has parenting time or decision-making responsibility over a child to give notice of their intention to the ex-spouse or to the ex-spouse to be, and to whomever may have contact order in respect of the child. So anyone that has an enforceable legal right to contact with the child, whether it's a parent, grandparent, uncle, aunt, uncle, whoever, you got to give notice. And I certainly agree with these provisions. But in 16.8 sub 3 and 16.9 sub 3, we see that the court may exempt a victim of family violence from these very sensible notice requirements. The pre-bill C-78 case law is full of examples where judges tell us that a parent cannot act unilaterally. If you are going to move, then you have to give notice. And generally speaking, first gain the court's permission. But we have an exemption in case of family violence. Remember, family violence is very widely defined. The extent to which these new statutory provisions will override the case law remains to be seen. Next slide. Is parental alienation a form of family violence? Hi, Dr. Warshak. Yes, many people, of course, know that lovely face. Psychologist Richard Warshak defined parental alienation as, I quote, a disturbance in which children, usually in the context of sharing a parent's negative attitudes, suffer an unreasonable aversion to a person or persons with whom they formerly enjoyed normal relations or with whom they would normally develop affectionate relations, end quote. He went on to explain that an alienated child is one, quote, who freely and persistently expresses unreasonable negative feelings and beliefs such as anger, hatred, rejection, and or fear towards a parent that are disproportionate to their actual experience, their actual experience of that parent, end quote. Next slide. The phenomenon of parental alienation is indirectly recognized, I say, in the Divorce Act. When determining the best interests of the child, 16 sub 3 sub C directs us to consider each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse. They didn't use the magic PA words, but I think 16 sub 3 sub C is clear. Next slide. Following this direction and in keeping with the definition of family violence, the courts have held that undermining a child's relationship with the other parent may be a form of family violence, as it may be psychologically harmful to both the child and to the other parent. And my authority for that proposition are the 5 cases on screen right there before you. If anyone wants this citation, the other citation that I have, I might not necessarily say it in my presentation, just send me an email, gene@complexfamilylaw.com. I'll be happy to provide the citations to you. Now, take, for example, S versus A. It's the first case on the list, Ontario Superior Court of Justice last year. In this case, the court emphasized that the mother had directly undermined the father's relationship with his children by refusing his sincere efforts to resolve the parenting issues outside of the courts. She accused the father of abuse in front of the children and forced one son to falsely report sexual abuse by his father of his younger sibling. The children's sense of security and self with respect to their father was, quote, overridden by the mother's determination to erase her former spouse from her life, end quote. The quote's from the judge's decision. The court found that the mother had alienated the father and as a result, transferred primary care of the boys to the father and granted him decision-making responsibility. Parental alienation is being recognized as a best interest factor, which, where necessary, can yield results such as the one awarded by the court to the father in S versus A. But on the flip side, unfounded claims of alienation have followed. For example, in Armstrong versus Copeland, it's a 2021 Ontario Superior Court of Justice case. The father sought to increase his parenting time with his daughter and claimed that the mother had a history of alienating the child from him. The mother wanted the father to have only limited and supervised contact because of what? His abusive behavior. The mother provided the court with emails that the father had sent her and her lawyer, in which he claimed they were alienating the child from him. Not a good idea, folks, to send heartfelt letters, emails to the opposing lawyer, and often to your ex. So what happened? The court found that the father's communications were often aggressive, demanding, threatening. In other words, they amounted to a pattern of threatening, coercive, and controlling behavior towards the mom, behavior that we all know now is defined as family violence under the Divorce Act. The court did not accept the father's claims of alienating behavior by the mother, but found that the father had a history of abusing the mother, which was further exacerbated by the current parenting order, which required both parents to do what? Communicate. The court chose to vary the parenting order, deciding that the father should have significantly reduced and supervised parenting time. Next slide. So is there a tort of family violence? Here's a case that says such a tort exists. It's a very recent case. Last year's expansion of the legal definition of family violence may have become more consequential than any of us had anticipated. 11 months after Bill C-78 came into force, the Superior Court agreed with the respondent mother that she was entitled to a brand new civil remedy for being a victim of family violence at the hands of her ex-spouse. The court awarded her, I wish I had the drum roll thing back here. The court awarded her $150,000 for the new tort of family violence. And that's the name of the case right there on your screen. It's presently under appeal. In addition to creating a novel tort, this decision is groundbreaking because if not overturned, it will, in my view, transform the framework of family law. In this case, Justice Mannheim explained that and I'm quoting here, the Divorce Act creates a complete statutory scheme when it comes to resolving financial issues post-separation, end quote. So far, so good. It is for this reason that courts have not seen fit to find that extraneous causes of action should be available to persons before the court in a family matter. In fact, the Supreme Court of Canada in the 1987 decision of Frame versus Smith opined with respect to the comprehensive scheme, in quotes, created by family law legislation, has said that it makes civil actions inappropriate. Actually, Frame versus Smith was an alienation case. Yet armed with the expanded definition of family violence, Justice Mannheim saw the experience of the respondent mother to be atypical and warranted recognizing this brand new tort. There was extensive ongoing bad behavior that came within the family violence definition. The judge appeared to hold to the view that the legislation created the standard, the husband breached that standard, therefore he was required to pay substantial damages. Now, one of the reasons given by Justice Mannheim for recognizing the tort of family violence is that although family law legislation is quite comprehensive when it comes to resolving financial issues following the separation, it does not address, according to the judge anyways, the legal issues that arise out of family violence. With that being said, the Divorce Act defines, as I've said already, family violence quite broadly. The experience of the mother in Ahluwalia was described by the court as years-long pattern of coercion and control. This is only one type of family violence described in Section 16 of the Divorce Act. As we shared earlier, we believe that the amendments bring parental alienation within the definition of family violence, There is no statutory financial remedy for being alienated from your children in family law, i.e. Frame versus Smith. So might there now be a remedy found in tort? Good question. Time will tell. Next. Proving family violence can be very challenging. In a case, and I'll probably mispronounce it, Wyatt versus Afowakwa Yaboa, it's a decision of the Ontario Court of Justice. The court, in 2021, the court acknowledged that one of the greatest challenges to Parliament's objective for family law is to better consider the impact of family violence. In this decision, Justice Stanley Scher said the following, and I quote, "The court is also very aware that family violence is sometimes difficult for the victim to prove. It is often not reported. There may be many reasons for this. There will often be no medical, police, or CAS reports to corroborate allegations of family violence." CAS, by the Children's Aid Society. Victims sometimes minimize and rationalize the abuse. The family violence can take place in private so that there are no witnesses. Control and coercion, come back again. Control and coercion can be subtle and only evident to the victim. Wow, end quote. I would argue that allegations of family violence must be proven on admissible and credible evidence. However, cases such as this Justice Scher decision here inform us that perhaps the tests of admissibility and credibility will be relaxed. That, to me, sounds somewhat dangerous. Next. So let's recap what we've learned this afternoon. Next. Firstly, the Divorce Act and some provincial legislation was amended to introduce and define the concept of family violence. Secondly, and I know I've said it many times, but the Divorce Act defines family violence very widely indeed. Thirdly, while courts have to give precedence to best interests of the child, family violence is clearly going to influence that analysis. Fourthly, those who engage in family violence may be deprived of parenting time and parental decision-making responsibilities. Next. Fifth, if you are someone who is engaged in family violence, you should give serious consideration to securing professional treatment and insights into your behavior so that one, you will be a better parent, and two, you hopefully will not be stripped of your parenting time and parental decision-making responsibilities. And I should really reword that. It should be so your child will not be stripped of the parenting time and having your input and allowing you to step up to your responsibilities. 6, measures that relate to family violence that are made in the criminal justice system and or in the child protection system could seriously affect the rights and responsibilities within the family law system. Reminder, note that I said measures, I didn't say orders. Orders certainly, but it doesn't have to be an order. An actual criminal conviction is not a requirement to effectively influence the family court. 7, in my view, parental alienation can be equated with family violence. 8, family violence, for now, is a new tort. You get damages, but that decision is under appeal. And the final thing we learned is, are the courts going to liberalize the level of proof needed to prove family violence? Next slide, please. Conclusions. The nuanced approach of the best interests of the child test means that the court may be prepared to order shared parenting arrangements, even where there have been acts of family violence. Take note of a case called Trisniki and Nasri. It's 2022 Ontario Superior Court of Justice. There we learned the court needs only to be satisfied that family violence is not a concern at the time of making the order and is not likely to reoccur. My friends, Recall what I said about if you are a perpetrator of family violence, what in my view you need to do in terms of treatment and courses and everything. And that ties into the point I just made here. Secondly, while reforms clearly require courts to consider family violence, the Divorce Act requires that the court consider the nature and recency. This, and that's in 16 sub 4 sub A. This way, the focus is on the parent's ability to cooperate in the future, not only on their past behavior. And next point, children can experience profound harm on account of behavior that might not constitute a crime under our criminal code. If you have perpetrated such harm, whether intentionally or not, then treatment and gaining insights to prevent reoccurrence, in my view, is the order of the day. If you are the victim of family violence, then marshal the evidence to prove what happened and show how that behavior's continuation is detrimental to your child. Family violence will have a greater influence now, more than ever, upon parenting time and parental responsibility for decision-making. Our talk today has tried to sensitize you to some of the factors that the court is going to be considering. Next slide. And next slide. Thank you very much. I have 2 minutes for questions, and then it's Brian Lover's turn.